for that.
All right. Good morning. It's 9 o'clock. We'll call to order the June 17th meeting of the Tennessee Real Estate Appraiser Commission. Heidi, do we have quorum?
Yes, I'm going to go ahead and take roll call and read
Perfect.
the notice. Notice of the June 17th, 2024 meeting of the Real Estate Appraiser Commission, including date, time, and location, has been noticed to the Real Estate Appraiser Commission website since July 5th, 2023. Additionally, this month's agenda has been posted on the website since May 31st, 2024. I'm going to go ahead and do roll call. Taylor Vandiver.
Here.
Eric Robinson.
Here.
Brett Mansfield.
Here.
Francine Mello.
Here.
Sandra Tuck. She popped up on Teams. Okay, she's on. Ms. Tuck is on Teams. Nelson Pratt.
Here.
Dr. Mark Sunderman.
Here.
And Will Haston.
Here.
All right, we have quorum, Chair.
Thank you. Next up is our agenda. Has everybody had an opportunity to take a look? We have a motion to adopt the agenda.
Motion to adopt.
We have a motion on the floor
Second.
and a second. All those in favor?
Aye.
Aye.
Any opposed? All right, motion carries. Next up is our March minutes. Again, has everybody had an opportunity to go over those? Edits, revisions? Motion to adopt those?
I'll make a motion to adopt those.
Got a motion on the floor?
Second. Second.
All right, all those in favor?
Aye.
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 Any opposed? Motion carries. Next up is our experience interview.
Yes, sir. We'll start with Mr. William Haston. You have Ryan Clark and Michael Belasco, both with recommendations as yes. Does that still stand for you?
Yes.
Okay. Brett, I didn't see any for you. Ms. Francine Mello, David Reznicek, I apologize if I got the name wrong, with a recommendation of yes.
Yes.
Yes, ma'am. Mr. Nelson Pratt, we have Nada Payne and Elijah Wilson, both with a recommendation of yes.
Yes.
Thank you. Ms. Sandra Tuck, we have Mohammed with a recommendation of yes. She pop in on chat or anything? Okay, we'll move on. And then Mr. Taylor Vandiver, we have Emily Potts, Logan Terry, and Nathaniel Shamblin, all with yes.
Yes.
Okay, thank you. Okay, with that, do we have a motion to accept the panel as so and recommended?
So moved.
All right, we have a motion from Mr. Mansfield. May we get a second?
Second.
We have a motion from Mr. Nelson Pratt. All in favor say aye.
Aye.
Any opposed? Hearing none, the experience interviews are approved.
Okay, thank you. Up next is our, education report. Turn it over.
I'd like to move that we approve the recommendations for the education report.
Okay, we've got a motion on the floor.
Second.
All right, all those in favor?
Aye.
Aye.
Any opposed? Motion carries for our education report. Up next is application reviews. Turn it over.
Yes, sir. We have two application reviews today. The first one's going to be an AMC application review, and the second one is going to be an appraiser review. You'll see when you open the attachment, it has the AMC application review for application 2165. And also next to you, you guys, you have a TSA printout so that you have something comparable to, for your review on what the applicant answered on their application. Essentially what it is the applicant declared yes on questions 1 and 4 on the declaration of owner form. They did provide a letter of explanation along with the supporting documents. You're specifically, you're looking at the Florida discipline is what we're referencing in it. There is a California in one, but that's as a reference to the Florida discipline. So if you have any questions or anything or need time to review.
I have a question. So
Yes, sir.
what was this filled out after the Florida or at the same time?
So the applicant received the California discipline and they went to apply for a license in Florida, and that's where they declared, they did not declare their California discipline. The applicant says that they received a temporary denial and they were later provided an AMC license. You have there the Florida notice of intent to deny. I asked the applicant, stop me if I shouldn't be saying something. I asked the applicant if they had further documentation from Florida stating that this denial is lifted, because the wording was somewhat new with temporary denial. They did not. However, we did look up on the Florida AMC website to verify that he does have an active AMC down there, and he is the owner for that AMC. So he was granted that license.
And then after that, on the Tennessee application, made the same.
He did declare. He declared, but what we're looking for is for the board to determine if he can be granted a license. Is it the substantiative cause? If there's the substantiative cause between what he answered and the outlining TSA information that I provided to you all. That's the printout that's next to you, sir. So based off what the applicant answered, this needed the board's review and approval for whether or not he will be granted a license in Tennessee.
And Heidi did a great job outlining all of that in front of you, because there's a lot of documents, and primarily you're looking at, in your judgment, do you believe there's substantive cause based on that temporary denial? And then Anna here will kind of help us with the guardrails if you have any legal questions as it pertains to that.
Just wanted to get a better overview of this. So he applied with Florida and then answered made an incorrect statement on that application?
Correct.
Okay.
In his statement, he said he accidentally answered no, and with not declaring his California discipline to Florida.
Okay. And so he applied, just to confirm that, he applied with Tennessee and Florida at the same time?
Well, he
No.
was already licensed with Florida and had an
Okay.
active AMC with them when he
Okay.
applied with us.
Okay.
Yes, sir.
But in Florida, they do have a license now, correct?
Yes, sir.
Okay. Anybody have any thoughts, discussion?
Yeah, I think the main thing is trying to determine, since this information came to, we have confirmed that Florida, whatever temporary restriction was lifted and they were granted a license, correct?
Yes, sir.
So really just determines, is there anything, if the state of Florida granted that license, is there really anything for us to discuss on that application? I mean, it just now, is there anything, issues, or it seems like there's no other issues for us to discuss as it relates to the Tennessee application, unless I'm missing something there?
Yeah, I think since he said no, we just have to grant approval. Would you like to put that in the form of a motion?
I will make that a motion that we grant approval.
Okay, we've got a motion on the floor.
Second.
Motion and a second. Any discussion? All those in favor?
Aye.
Aye.
Any opposed? All right, motion carries.
Thank you.
Excellent. The next application review is for an appraiser for a Ms. Lisa Grooms, license 4154, and Ms. Taylor Hinton will be leading and helping discuss that with you all.
Okay, just to give you guys a brief overview, Ms. Grooms essentially had a license that closed back in 2015. At the time that she closed her license, she had an active complaint. Based on the USPAP violations that were found, the commission at that time voted to assess a $500 civil penalty. However, when she closed her license, they closed and flagged the case, which means when she came back to reapply, the case was flagged, so we got notified she's looking to reapply for her license. So what you guys have to vote on is if she will have to resolve the previous issue with the consent order, the $500 civil penalty, and be able to reapply, or if you guys want to take a different avenue and just let her reapply. I don't know if she has anything she wants to mention. She's in the crowd.
I want to disclose something as well. I know Ms. Crooms personally. Our families are friends. Our kids are friends. And I've encouraged her to come before you guys today. So I just wanted to disclose that before we discuss.
And that's, thank you for that information. Appreciate that. And of course, obviously, when it comes time to the vote, then you'll have to recuse. And of course, you already understand that and know that. But just as a reminder for those that would know that might be listening, you know, we're just letting them know that as procedure would warrant that that would be the case. But thank you for those comments. And then if you have any questions, Ms. Grooms can come to the mic as well.
Can you discuss the prior complaint?
Yes, so we don't have much information just because it was back before we digitalized everything, but we do have the consent order that was proposed to her. And basically, I can kind of just give an overview of the violations that were found. Okay, so the appraisal was subject to an expert review, and it says the filing violations were noted in the reviewer's report for the subject property. It says there is confusion as to whether the property has a basement, cellar, or crawl space. The complainant calls the area basement. The appraiser in the appraisal report indicates that it is a crawl space, but then describes the area as a cellar/crawl space in their response to the complaint. An exterior picture of the side of the subject property gives the impression that there is more than a crawl space there. MLS describes a basement area as being partial/unfinished. A head and shoulders viewing of this would be required if the area is a crawl space. However, if the area is a cellar or basement, then the appraiser, per FHA requirements, would need to personally enter into the area as far as possible to inspect for readily observable items that affect the soundness, safety, and security of the property. If such items exist, then they're to be disclosed in the report and repairs required. Since the appraiser admits that they only performed a head and shoulders inspection from the foundation access opening, they admit that they did not enter into the basement/cellar area and as a result neglected to discover the above stated conditions affecting the soundness and safety of the property. Then it states, an opinion of the site value is provided in the cost approach. The following statement is provided in support of the site value opinion. Site value from recent sales of vacant sites in the area or extraction. There are no land sales or extraction techniques provided in the report to support a site value opinion. There is no summary of support and no regulation of the data to support any of the site value at all. Since an opinion of the site value is by definition an appraisal, all applicable standards, rules, and standard 1 and 2 are required by the appraiser. Then it states that a market condition adjustment is made to sale 1, but no adjustment is made to sale 3. The stated reason is that the market has increased the sale comparable 1. However, on the front page of the report, the appraiser indicates the values are stable. The adjustment at sale 1 is inconsistent with the rest of the report. Also, no support is summarized in the report or found in the work file. A $50,000 location adjustment is made to sale 3. No explanation is provided in the report and the work file to support the needed adjustment for that amount. A $50 per GLA adjustment is made along with several other minor adjustments with no explanation or support found in the report or work file. And then it lists a few other things that says the appraiser did not include in the certification a statement regarding any previous performance of services related to the subject within the 3 previous years. The appraiser failed to make a sales concession adjustment for comparable 3. An opinion of the site value is provided in the cost approach of the report, but there is no opinion given for the highest and best use of the site as vacant. And it says then the final one was the content of an appraisal report must contain a summarization of the support and rationale for appraiser's opinion of its highest and best use. This was not provided in the appraisal report under this review. And so the commission at that time voted to assess a $500 civil penalty.
Okay, thank you. So reapplying, what does that entail?
So her license would close in 2015, and now she's looking to reapply, so she would have to perform all the CE. Is that correct? And then what else do you need to reapply? Sorry, I'm not sure, 100% sure of the requirements. Okay, so she was last licensed in 2015, and due to several complaints being submitted, she need to appear before the board. If she were to reapply, she will need to submit all due continuing education from the previous license period, retest, and pay the outstanding civil penalty.
When you said several complaints, was this the complaint you just read? Was that just one complaint?
That was one, so that's the only one that had any civil penalty.
Okay.
So
Okay. But there were other complaints as well?
that's what's noted, but I don't have any information on those previous ones.
What would be a different avenue? And is there, this ever happened or what?
You know, boards have different, you know, they have different processes. So we typically, we would, if they meet all the requirements, then they would obviously apply unless there's some sort of basically a flag. That's sort of a pseudo flag is what they did. But that they have that prerogative. They're saying, hey, just come before us. We'd like to, you know, talk to you again. But of course, that was 9 years ago, so it's been a while. And so this is her first, you know, appearance before the board since then. You're not beholden to that precedent. That's just something that they exercised, and then they subjectively decided to enforce, or they wanted that re-review basically, and just kind of see where she was at since then. But yeah, she would be, if the board would allow her to reapply, she'd be subject to all the requirements of any reapplication. Of course, she has to, you know, settle up where if there's anything lacking, those deficiencies, as noted, the CE, the retest. I think that the penalty as well. So just settle up for that disciplinary action, then she would reapply then. Of course, and then once you're an active licensee, you're subject to all discipline or otherwise, and at that point.
So just confirm, this is just permission in order for her to reapply?
Yeah.
Okay.
And to clarify, so she never signed the consent order just because it was closed at that point. So you do have the ability to not require her to sign the consent order and pay the civil penalty, or to enforce what the previous commission voted on before she reapplies.
And after the reapplication, if granted, have to go through all the education requirements?
Correct,
And the
yes.
test, okay.
I mean, since you indicated that there was multiple claims, is there any reason we wouldn't enact the civil penalty that the previous board had done in addition to the normal application process? I mean, any discussion on that? Oh, go ahead.
Is you said she's in the room, correct? Can I ask her a question? Yeah. Okay. Thank you for coming. We appreciate it. Can you tell me kind of what you've been doing? I mean, have you been working in the appraisal field since that time, or have you just totally gotten out of it, or?
I've completely gotten out of it. I'm in dental now, so I work in oral surgery. Been doing that for the last 9 years.
So if approved, you would, there'd be the consent order, the continuing education, and then retaking the test?
Absolutely.
Is that where things stand?
Yes.
Okay. All right. Any other questions for Ms. Grooms? All right. Well, I'll make a motion that we accept the resubmission or reapplication.
Make a motion to accept that.
Okay. Got a motion and a second on the floor.
And just to clarify, you want to enforce the previous consent order?
Yeah, I mean, I think that's on the
Okay.
table, correct?
Yes.
Yeah. Yes. Any further discussion, questions? All those in favor?
Aye.
Any opposed?
Abstain.
Okay. Motion carries. Thank you,
Thank
Ms.
you.
Grooms. Okay, I think that that completes our application review. Up next is our director's report.
Yes, sir. We'll start going over the budget. We'll open up that attachment. Let me flip this. There we go. We are going to be looking at the months of February to April. And specifically, you're going to see, which I'm sure has already stood out when you all looked at this, under the expenses for deductions. We had quite the deductions come out in February and March. You'll see 16,000 there under February. And then you'll see a big chunk of 73,000 there in February. Those are our ASC and AMC registry fees. And if you scroll up in those same months, you'll also see for our revenue, there's quite the increase there, with February being 120,000 and March being 98,000. And what those are is those are the incoming fees from the ASCs to the AMCs. So that deduction is just not coming out of nothing. We get the money from the AMCs, and then we push that over to the registry. So for each year, you'll see January to March, that's our AMC panel reporting. So when we go over this again next year, those are where you're going to see those increases and decreases when it comes to the revenue and then the appraiser expenses. Also for March, included in that 73 is our in-state conference training that some of us attended. So that was also a part of that deduction in there. We did go into a slight deficit for March. You'll see that down there at the bottom for that 14,000, but we recovered. And we are sitting at a healthy net and surplus balance. We have 197 that we're sitting at. Are there any questions about the budget report? No? Okay, good. And the only other item for the director's report is the Fall Aero Conference. And that is going to be October 28th to the 30th, Monday through Wednesday. That's going to be in Boston. We're going to go ahead and select 2 members for approval. We're trying to select members that maybe have not been so that they have the opportunity to attend one of the conferences.
Does anybody have any interest?
I do.
Can you repeat those dates one more time?
October 28th to the 30th, that's a Monday through Wednesday. And that is in Boston.
Could I get back on that, just based on the schedule?
You can. We could do like 2 primary, 1 alternate, or or however you want to do that. We can approve 3, and then the other 2 can go in a death cage match or something. But but we just need to make sure we have enough coverage so that we fill those 2 slots. Yeah.
I'd consider it.
Okay. All right. So we'll just approve.
The 3, and then
Yep.
to figure out schedules, who
Yep.
can go.
That sounds perfect.
Do we need to vote on that?
We would, yeah.
Okay. All right.
Oh, you're good.
We'll make a motion that we approve the 3 candidates for the Fall Aero Conference.
So Dr. Sunderman, Ms. Francie Mello, and Mr. Nelson Pratt, sir?
Yes.
Motion to approve?
Okay. Got a motion and a second. All those in favor?
Aye.
Any opposed? Okay, motion carries.
I get into your email.
Is that Ms. Tuck over on the phone? Ms. Tuck?
Yes, I finally got in. I'm sorry I was late. I couldn't
No,
get
it's okay. Did you have
in.
some comments or anything that you'd like to add to what you've heard so far?
The only thing is, I would go to Boston if no one wants to go that hasn't been before.
Okay, that sounds perfect. We'll tell you what, we'll have another meeting before then. So that's fine. But we'll just approve who we have, and then if it looks like one of those alternates fall out, then Ms. Tuck will reach out to you. How about that?
Okay, thank
All right,
you.
thank you.
That's all I have, Chair, for the
Okay.
director's report.
Thank you. Up next is public comments.
Yes, at this time, for people that are present in the room, you can come up for public comments. Just please ensure that you are signed in and that you push the red button so that your comments are, or push the button so the red light shows so that your comments are captured for this meeting. Comments are related to items on the agenda, and if you would please keep comments to about 2 to 3 minutes. And we can begin.
We'll just go down the list if that's okay. We got Mr. Kevin McGuigan.
Good morning, Commission. Hi, my name is Kevin McGuigan, and I'm a certified general appraiser here in Nashville. I have my MAI designation and currently the president of the Tennessee Appraiser Coalition, organization of approximately 75 appraisers across the state. I have 20 years' experience and care a lot about the profession. I'm here this morning to hopefully initiate the discussion of appraiser complaint reform. I've set up my comments like an appraisal. My scope of work is to identify the problem, present the data, and reconcile a conclusion. The problem, in my personal opinion, is that the complaint process is too punitive for frivolous accusations. The process is long, can be 6 to 12 months or more, personally time-consuming, expensive both from an E&O insurance premiums to potentially hiring outside counsel, and very stressful. I believe this painful process is totally reasonable and acceptable if you have a serious fact-based complaint against you. If the complaint is frivolous, flimsy, without any evidence, or motivated by litigation, the current process is way too penalizing. My research began by first speaking to peer appraisers and reviewers. This led me to speak in depth with Scott DeBazio, the Appraisal Institute's national lobbyist for state and industry affairs, and Peter Christensen, an attorney and teacher of appraiser liability. Both have a national perspective. They provided me with 4 comps of how other states handle complaints differently. Minnesota changed the label of their complaint form to an allegation. An allegation doesn't rise to the level of a complaint until probable cause is proven. In Florida, they have probable cause panels. 2 appraisers are assigned for an informal review of an appraisal, and there is transparency on who these appraisers are. In Texas, in the intake process, the state focuses on if they have jurisdiction for the complaint. I spoke with their legal assistant, Lucy Roman, who stated they often dismiss complaints about an appraiser's behavior as they do not have jurisdiction over business practices. In California, on their website, they state, once a complaint is received, an investigator will then screen the complaint package. Screening will result in either closing the case or assigning the case for extended investigation. Investigators are experienced licensed appraisers, and investigators do not perform appraisal reviews or field reviews. In all 4 of these states, there's a process to filter and dismiss frivolous cases. My 5th comp is the process attorneys have in Tennessee with their Board of Professional Responsibility. Per their website, the chair of the board may administratively dismiss a complaint without investigation that is not sufficiently credible or verifiable through objective means or does not state sufficient evidence to support the allegations. My reconciliation is that these 5 comps have solved the puzzle on how both to dismiss frivolous cases and prosecute bad actors. I understand there's a federal law that requires appraisal complaints to be investigated, and I believe real complaints should be. I understand that Tennessee law has its own rules and procedures under the commerce and insurance umbrella. I hope we can work together to modify the current process to solve this problem. To conclude, I want to say that I'm here because I love the profession. I want to make it better. I want what is best for appraisers, which includes public trust. We should absolutely discipline appraisers that deserve it. I hope to work together to accomplish complaint reform.
Thank you, Mr. McGuigan.
Thank you so much. We have Joe Pat McGuigan. Did I say that right?
No comment.
No comment? Hal Humphreys? Yes.
Hey, Mr. Humphreys, will you make sure that microphone is...
Sorry about that. I'm Hal Humphrey, certified general here in Tennessee for over 30 years. I too love this industry. My father was an appraiser. I grew up holding the dumb end of the tape. I've been around for a long time. I want to second what Kevin had to say and urge the board to consider complaint review. In addition to the comps Kevin provided, West Virginia has a program where they provide mentors to people who've had complaints filed against them, Texas, in addition to dealing with jurisdictional issues, can they address this issue or not? They provide mentors for appraisers who have had complaints filed against them that are legitimate complaints, but it doesn't rise to the level of nefarious intent. It rises to possibly incompetence. The entire idea of appraisal review was initially to help us all be better appraisers, not to bust appraisers. And I think those two mentor processes are an interesting take on it. Colorado has a bill before their Senate right now where they're addressing this very issue. And one of the things they've put in that they're trying to push through, and I don't know if they're going to have any luck with it, is the idea of having a fee attached for frivolous complaints. If a complaint is found to be frivolous, the person that filed the complaint will have to pay that fee. So there are options out there. I think the complaint process, again, if there are bad actors out there, we have to get them out of this business. I totally have no problem with that. But for complaints against good appraisers that are out there doing a good job and somebody's just mad because they didn't give value to the custom koi pond, I think we need to have a way to vet those before they go up to the full complaint stage. So that's all I have to say.
Thank you.
Thank you, Mr. Humphreys. The next name on here is Victor Andrews.
No comment.
No comment. Ben Baggett.
No comment.
No comment. Mark Young.
No comment.
Okay. Randy Button.
No comment.
Okay. And David Wally.
No comment.
Is there anyone else in the room that has not signed in that would like to make a comment, or online? No one here? Anyone online, Alex? Chair, that completes our public comments portion.
Can we open that up for discussion, or? Okay. I think it would, a good place to start would, if you can just kind of give a summary of our current complaint process and how that works.
Sure, I can do that. This is Anna Matlock, Board Attorney. It's clear from the comments that there is confusion about how the complaint process in Tennessee works. So when complaints come in before the commission, we receive them. I think first I would like to start off by stating a couple of things. The Department of Commerce and Insurance is an umbrella agency, so we house 26 different professions, including the Appraiser Commission. So this is not the only board. The complaint process across the board is uniform in how it works, except the Appraisers Commission has something that's different that no other boards have, and that's our conditional dismissal. That's not something that we use in any of our other programs, and I'll talk about that in a second. So the main reason that we are here, and I think that's important for everyone to remember, is consumer protection. And so, yes, the board does accept complaints from consumers. We accept complaints from banks. We accept anonymous complaints. That is how it works across the board for all of our programs. So when a complaint is received, it is received by our centralized complaints division. Individuals are required to fill out a form and attach certain information. Based upon that information, at that time, it's determined first if we have sufficient information. So if someone puts a simple sentence or something related to a complaint, oftentimes that time a complaint will come to me, and I'll make a determination whether we have sufficient as information to move forward or not. So those complaints are never brought to you, the ones that are closed on the initial part. So it won't even show up as, it will just say the complaint is closed. Also, a determination is made whether the board has jurisdiction or not. Because we have different one form for all of our different programs, sometimes people will fill out the wrong information for the wrong board. Also, this board doesn't have jurisdiction over certain complaints. So if it's something related to a contractual issue, or if it's related strictly to value, those complaints are closed because the board does not have jurisdiction over those complaints. So there are certain checkpoints that before the complaints come to us. And then at that point, the complaints are sent to the respondent for response. Respondent has the opportunity to submit a response to the complaint. Unlike other boards, this board does not have a requirement that the complaint be responded to, but most of the individuals do respond at that point. If the complaint is related to the appraisal report, it is then sent out for determination. All the documents are collected. It's received at the legal division. And then at that point, our disciplinary counsel, Ms. Hilton, will look at the complaint, determine if it's related to the appraisal report or if it's just a general complaint related to something else. If it's related to the appraisal report, then the determination will be made for the complaint to be sent out for expert review. Our expert reviewers are individuals that have responded to our requests for proposals, which are contracts that we give out to individuals that hold licenses in Tennessee in good standing, along with all of the different requirements that choose to respond to be our expert reviewers, and they will look at our complaints. And the complaints are then analyzed based on USPAP, and that is how it is found. So we will send that out for review. They'll look at the work file, information comes back, report, and it'll detail any issues that are found, if any. So if the individual comes back with findings from the expert review report at that time, and then a determination is made whether that person has a complaint or not in the past. If they don't, then a conditional dismissal is offered to that individual. Conditional dismissal is where the person has the individual opportunity to sign the conditional dismissal, and certain educational courses are recommended at that point. Education at that point is accepted and it's counted for their continuing education. And then after the continuing education is completed, the complaint is dismissed. So it does not show up as a disciplinary infraction on their complaint file or anything of that kind. If the individual's already had a complaint above and beyond that, it is put on the legal report and presented to you all for determination. So those complaints are summarized, the summary from the complainant, the summary from the respondent, and then the summaries that come from the expert reviewers. And then at that point, the legal division makes a recommendation to the commission. That information is presented to you anonymously because we don't want for purposes, so we can be impartial, because that's really important when presenting these matters to you. And then at that point, it's presented to you at the commission meeting. We do it case by case. Sometimes things are grouped together. And then you make a decision whether to accept that recommendation or to amend that recommendation at that point, or make your own recommendation of any kind. So typically this board is more so on the educational point of when it comes to discipline, but occasionally things above that, including civil penalties and suspension, have happened very rarely. And then at that point, I would say nearly 100% of our complaints are resolved at that point, because this commission has not had a formal hearing since 2018. So that's kind of essentially how the complaint process works for this board and the commission.
Thank you for that. One other question, just an estimate of how many complaints would you say that are received? What percentage actually gets to the commission and that are thrown?
Well, we have seen a significant decrease in complaints now, since we don't take a certain type of complaint or a tip that was received. So the amount of complaints that have come in from the commission is significantly decreased. For example, your legal report today only has 4 complaints brought to you. So I would say related to that, we don't have a high volume. So the amount of complaints that probably make it to the board would probably be around, I can't even come up with a number because we don't keep those statistics. I would say close to like 90%.
And for this time period, we had 3 conditional dismissals that were on the report, but then went out for conditional dismissal and came off the report.
May I ask a question?
Sure.
From what you indicated, it sounds like all the different commissions are working under the same type policy.
Yes.
Even so, if we had wanted to make changes, is that even something we can do? Or are we kind of stuck under this, the way the other commissions are handling things? I mean, in other words, if we had decided we agree things need to change based upon recommendations made, or would we even be able to do so?
Probably the answer would be within reason. I don't foresee some of the proposals that have been presented as really kind of a possibility, just based upon time and resources of how those types of matters work. But like I said, this board has conditional dismissals. Nobody else has that. It's not related. That's not how it a tip kind of works for the other things. So if there is something that the board or commission wanted to discuss moving forward, that is a possibility. But I would say it's very limited because, again, our complaint process is uniform for a reason, and that is to make sure that we treat all of our complaints the same. So when we do have issues or complaints, we can let the individual know that we followed our complaint process, our standard, our SOP, our standard procedures of how we do those things, to let them know that there wasn't any kind of special treatment given related to the matters.
I like that you noticed some of the similarities between some of the other jurisdictions as well. There's 4 guardrails when it comes to complaints. You have ASC Policy Statement 7, Section B2. It requires, quote, that states investigate allegations of appraiser misconduct or wrongdoing. And so you've got, that's one guardrail, and then there's they give requirements as a result of that effective enforcement. So we got federal standards that require an investigation. So you'd have to go through the process. You can't, there's preliminary reviews, or that's there's some discussion about that. I know, some of the jurisdictions I heard probable case panels for complaints, a jurisdiction for complaints to determine if there's jurisdiction, investigator screening to close complaints. That's what you're doing, and when you get a complaint, you're looking to see if anything falls under USPAP, and if it doesn't, then the request then is to close. And so, and if it does fall under USPAP, then an investigator and this board, all of which are our appraisers, will make that determination and recommendation as well. And then West Virginia, I heard they have a mentor program, and thank you, Hal, for bringing that forward too. That was interesting. But that's sort of what our version of the conditional dismissal is. That's an intermediary sort of step. Everyone also has to is subject to the Uniform Administrative Procedures Act, Title IV and Chapter 5. Of course, you have our rules and our laws, that we're subject to as well. And then you've got that 4th rail, which is departmental policy. And so you're looking at 4 different sort of filters that you have to run, whatever. So your changes would be somewhat limited, and then and everybody has due process. I mean, and if someone didn't like the recommendations, then they could escalate that to a formal hearing as well. So, and then you have other courts that could rule into that as well, that they could appeal to, should the board. And we have a policy director even. So there's several protections to make sure that there's consistency within the rules and the laws, and that we aren't too punitive. That's the idea, and then for which you have all of those rails to protect against that. But ultimately, in view here, as well, the appraiser is a part of the public, but it's public protection, consumer protection, health, safety, and welfare. That's what's in view when we're making these considerations, but all within USPAP. So, being late or personality doesn't really necessarily fall under USPAP. So if somebody doesn't like their appraiser, then you're not entitled to punish that appraiser for that. So you'd have to, and that's also under federal guidelines. If you look at Part B, that same section we're in as well, I like what they say. One thing, the summary of requirements, the state must appropriate document enforcement files and include rationale. So it's not arbitrary. It's not capricious. It's not random, So, and we get audited biennially, for which they look at our complaints. So The jurisdictions are investigating complaints. Now, where that investigator or that appraiser comes into the process may be determined. But if there's going to be an agreed citation going out, then an appraiser has looked at it and determined that there is a violation of USPAP.
Thank you. Just one more question. So if there was a change to be made, you're talking about that we would be changing law and would be limited in what?
Not necessarily the law. It would have to be a change akin that I'd have to bring up to other people above me, because I can't make that unilateral decision myself. So I'd need to, of course, discuss it with the legal management team, and we'd have to talk with the administration as well to make sure if that was something that were to occur related to the complaint process. I will say some of the issues that were brought up are not things that I've not heard before related to this board, especially related to E&O. That's a big complaint that we've heard from individuals beforehand about changing the name. And if we change the name, whether it says you've had a complaint or we change it to allegation or a grievance, my issue with that is that, okay, then the E&O companies change what they ask for in the future to include allegations, grievances, those types of matters. Again, when something has been assessed to an individual, if they disagree with it, they have the opportunity. They don't have to sign a consent order. A consent order is merely an offer of settlement. That's what it is at that point. Nothing that the only things that this commission would assess that doesn't necessarily have a level of discretion would be the letters of instructions or letters of warning. But again, those things are considered to be not even really discipline related to that. But like consent orders are offers of settlement. So if someone disagrees, then they have the opportunity to come before you and in an administrative hearing, and which is essentially a mini trial. So, but that doesn't happen with this board. Of course, those things are offered to individuals at that point. It's detailed in the document that everyone's given that's like 6 pages long, letting them know their different rights and abilities that they have. So if there's something or a change that the board wants to consider, conversations have to occur higher than right here.
And then one other clarification in addition to summary of requirements on AAC Policy 7, number 4 states must track complaints of alleged appraiser misconduct or wrongdoing using a complaint log. And so a complaint by any other name is still a complaint. So even if that's how you log it. So even if there's allegations of alleged appraiser alleged, and one of the things I heard about Minnesota is they evaluate allegations. Well, they would still have to log that, and it's still a complaint. Now you can't stop submissions of frivolous complaints. What you do with it, though, that's really at issue, and those are within all the guidelines as stated, the guardrails. So and. Anna did a good job explaining the departmental policy. There's obviously an admin element as well that would have to be consulted, but even what you could do would be very limited. Even what admin could do would be very limited within the other guardrails.
Thank you so much for explaining that. That's super helpful. Ms. Malik, so basically all the frivolous complaints that would come before us, you sort of filter those out before. All the ones we're reviewing are the more serious complaints, and the ones that were not as serious are filtered out before they get to us. Is that correct?
So frivolous, loaded word, right? But if a complaint does not have, like, individual is not particularly, like, the information is just lacking, those will be closed. But if there is something where we've had complaints where individuals have just been, displeased with someone's performance, so that might seem frivolous to the appraiser, might not seem frivolous to me, related to that and at that point. But again, there's an opportunity to respond to that, and then if the complaint is, it's ultimately closed. So like there's not a process in which that all of our complaints, like Glenn was stating before, are logged and we receive them. And so if it's closed, it's closed. That's what it says in our system. Like when we look at individuals' history and we pull up, it might say it's been dismissed for no jurisdiction, dismissed, closed administratively. Those are also an opportunity of complaints to close administratively. If something, we have the ability to find duplicative complaints. So if someone was upset because their complaint was closed and then they decide to file it again, I'm going to close that complaint as duplicative. I'm not going to make it go through the complaint process again, because that is a waste of time and resources. But some of the complaints related to who it is, I'm not able to tell you exactly what our definitions of frivolous are probably going to be very different. But that it's summarized what we have to you, exactly what it is. We provide all of the information to you that we have at that point. And there have been times where we've presented something to you and the board has decided there's nothing here. But again, we do have a duty to listen to individuals when they file those complaints and to make sure that it goes to the complaint process, and then those complaints are closed at that point. We don't want to, I think, well, I would caution against the board from closing complaints unilaterally, as we don't, it is important to allow consumers the opportunity, if there is an issue, to voice those opinions. Sometimes individuals might find something they put in the complaint process that shouldn't be a complaint. Like sometimes we get public records requests sometimes, so those are closed. So it's all about related to what goes in it and then how it's handled at that point. But that's kind of like more context as to how it goes related to that. But again, I don't think, unless you would like these attorneys, us to make those unilateral decisions of, let's close this. Like, for example, decided not to hear tips. That's easy, that's hard and fast, unless it's signed by an individual in their name, which we heard more about at the Aero conference, anywho, related to that. So that's easy, but then again, no complaint fits the same bucket. Sometimes things are a little bit different, but if it was a more high volume complaint board, I think that is something that we would talk about, but right now it's very low.
I wanted to state that I very much appreciate Anna and Taylor, y'all's hard work for the board. In saying that, and I know that we've discussed, if we wanted to go down the road, what does that look like from a commission standpoint if we wanted to explore other options and how to streamline the complaint process? Is this a special meeting amongst the commission? Do we have to set another date? What does that process look like?
I think what it looks like is that we decide to, to have like more discussion at the next meeting. And then, because, as the Sunshine Law permits, all discussions have to be permitted in the open. So this is not something we could do, would never do, without the ability for the public to attend. So it would be, put something under new business, discussing possibly the complaint process, what it is. But if there are like specific things of which the commission is wanting to possibly consider before that meeting, if you have like very specific things, I'd encourage you to possibly go ahead and send those over to us so I can get that information and buyback from the legal admin and the administrative team related here. So then, because at that point, anything we decide has to go through those approval process. And so if we wanted to do that, I can give you what their thoughts and are related to that. So that's what I think it looks like at that point.
So is it something we could take some of those other states and what they're doing and have them take a look at that and say, hey, this would or would not work here, or at least to kind of make sure that we're...
It is, but I would, if we were to do that, I would want you to have more so of like a very concrete idea of what you would like to do, instead of just pitching ideas from different board, like different jurisdictions, because I think the more specific you are and the reasons for wanting to do it, that would be easier to have and go and discuss than, hey, this is what, you know, Wyoming, Hawaii, Alaska decide to do, because that's very easy to just unilaterally just say no. So if you heard something today that you're like, yes, let's definitely do that. This is what we would like it to look like in our mind. That would be better than to just kind of have a wish list of types of things. The other thing that I would say is, when it comes to the only concerns I had related to some of the proposals that were brought before is, until recently, this board has had an extremely difficult time getting expert reviewers to review our complaints. So things have taken a while because we didn't have reviewers to look at our complaints. And if individuals don't tell us, like, don't respond to the request for production that we do, or proposals related to those, we don't have expert reviewers to look at those complaints. And so then that is when we would have to, in those cases, farm them out to the board to look at that point. But I think the good thing related to the difference of having expert reviews and having the board and having that delineation is because if we do go to the administrative process, if the individual, for example, Chairman Mansfield, if you were to look at the complaint and review it, you wouldn't be on the hearing panel for that day. Because you know who that individual is. That might be an opportunity at that point where you have to testify as an expert reviewer, because in our request for proposals, witness prep, all of those things, letting them know that they're potentially having to include on the, be included in the administrative process is something that we do. So when we send it to the board, that's kind of our Hail Mary at that point. So if there is something, then when the next time proposals go out, be an expert reviewer. Also remember that we are a state entity, and so our rates are not going to be able to necessarily match what the going rates are for a normal proposal in the residential or commercial space. So I think that's also maybe possibly a deterrence. I don't know what it is, but if we don't have the people to look at the complaints to review them, then that's another issue that we have to look at too.
So is that a set, I'm going to go down a rabbit trail, so excuse me, but do we have a full complement of reviewers right now, expert reviewers?
I would say that we have like right now we have 4.
And is that?
So but the last time I think that we did an expert, like when I worked on the last proposal with the contracts and procurement team, we were looking anywhere from 4 to 7 individuals for residential, and then 2 to 3 for commercial. So there's definitely, of course, when we do that, room for more. We would love to have more, but again, we're at a time where there's like a higher volume. That would be great, but again, we try not, when individuals have those conflicts, that because they do occur, because the appraisal community is smaller. So sometimes they're like, I know this person, I can't do that. But we have a pool of 4, but the proposals when we send do have the ability to be more.
And did you say the fee that the commission pays the reviewer is not commensurate with what they would get if they were?
So the contracts depend. So it depends on what kind of proposal that we send out. Either we try and set a fee that the individual was to receive, and I try to ask individuals, like, what is the going rate for commercial appraisal, residential appraisal, and try to match that. But then there are also opportunities for individuals to pitch their own fees of what they would like. There's that opportunity for an RFP to say, I would like to set it at this amount. We had to run the last RFP at least once or twice because we couldn't get people to respond. So that's kind of the issue that we have there too.
Is the RFP sent out to appraisers via email? Is it, did the appraiser have to go to?
Yeah, it's sent
Okay.
out electronically. So
Okay.
we've had appraisers that have been, licensed in multiple jurisdictions. More so, you're going to see that in our West Tennessee individuals that may hold a license also like in Arkansas, Mississippi, and Tennessee. That's happened before. But again, we have like certain standards, how long you've had to be an appraisal, a year, the amount. We look at your disciplinary record. We look at a set amount of appraisals that have been done that request those appraisals. It's a process of what's to go through, but sometimes when we send those out, we don't get responses.
I know in the past we've discussed too with the reviewers, there's not a standard form or template either that they're to utilize. And so that, makes things a little bit difficult as well from a review standpoint.
I would say, though we don't give them a standard form, they all look the same. They're all using the same form. So it's like a subsection of this is this section, here's what I found. This is this section, here's what I found. It's all kind of broken down pretty much the same by each reviewer, I would say.
But if a reviewer was like a newer reviewer were to ask, hey, what does that look like? We can send reviews that have been sent before. Like if it's a form that we need to fill out, it would basically be based upon the ones that we've received before and send that to individuals. But again, it's up to their ability, their decision, their discretion, what they would like to submit back to us.
And so circling back, so if we have any ideas or thoughts about potential changes, you would like for us to get those to you in writing, and then at our next meeting, we can discuss if that's a possibility and what that would look like.
Yeah, we do that with other boards. Anytime we want to make sure that something is actionable, and so what I've always done with our other board members is that they're our experts, so we solicit responses from them, and then I can collate all of that, and I'll run it through Anna, obviously, and our leadership as well. And then we can make sure we have all the resources that you need to have that discussion. And typically, what I'll do is collate all those responses into a work product, a draft, and then we can sort of bring those resources to bear to see if you even need it or if there are opportunities for, to make those changes or edits if the board seems fit and it also aligns with the other four guardrails or falls within that structure, that scheme. So yeah, just send bottom line, send what you got to me, and then I'll collate all that. And once we have a work product with something that's actionable, that the board can do something with, then we can put it on the agenda, and then have that discussion then.
Perfect. I think it's a great place to start. Does anybody else have any further comments?
That's great. I appreciate you guys coming in, talking to us. Thanks so much.
I do have one follow-up question. Sorry about that. Just to clarify, when it's closed or dismissed internally before it gets to us, is that something, I know E&O has brought up a couple of times, is that something that, would you have to state that if it was dismissed before, if it was closed to you prior to?
I mean, I've never had anyone come ask that question of me, but if it had been closed administratively, I wouldn't say that would be considered to be a complaint at that point, because it did not go through the complaint process. It's going to show up in our system as dismissed, because that's just like closed, dismissed, those nomenclature and how it's gone. But whether the E&O providers decide that it's a complaint or not, we never looked at it.
I'd like to say a few things. Having experienced, seen another appraiser go through this process, it's probably 10 or more years ago, so I'm sure some things may have changed. But there is an element of feeling guilty until you prove yourself innocent, which I feel like is kind of the core of this process, or the core of the problem with the process. And whether that's the intent of how it's written or not, that's the feeling. And that's not a good feeling as an appraiser to go through that. And there's probably things going on behind the scenes administratively that the appraiser does not know about. So there's, you mentioned not having expert reviewers and that sort of thing. There's a time element that adds to the stress and adds to the confusion about the process. So if I were to be making a recommendation, what I would like to maybe do is ask that we add a board function to the process prior to it being sent to the expert reviewer. Because, who knows what the origin of the complaint actually is, but once it goes to the expert reviewer, it now becomes a USPAP situation. And it may not have been a USPAP situation. It may have already gone through a bank's USPAP review. It may have already gone through a review process, but now you bring someone else in there who is feeling like this person, they know a complaint has been made and feeling like, hey, I got to find something to send back to the state. And so just that whole part of the process doesn't feel good from an appraisal perspective. And then, you're forced to defend yourself, prove yourself that you're not guilty of these things. And I don't know, that's the part, the uncertainty and the feeling that the process leads to.
Sorry, go ahead. No, and just to touch on that a little bit, as Anna mentioned, we are here to protect the consumers. So we have to allow the consumers an outlet to file their complaints if they feel a violation has occurred. We do have pass-throughs before it comes over to me for any disciplinary action. At that point, I'm not an appraiser, so I'm not going to unilaterally make decisions if I think a USPAP violation has occurred or not. So that's why it goes to expert reviewers, that we have that pass-through in order to have somebody that is in the industry reviewing these and finding any issues. I am in constant contact with respondents and complainants that are reaching out to me. I handle the day-to-day for the complaints, and so I don't want people to feel that they're not here. I understand it could take, it's a delayed process because of expert reviewers, but if somebody calls me with a question, I talk to them. I'm very open with the complaint process, and so people are kept up to date on what's going on.
And I just want to speak to the personal element of what you're describing. I really appreciate you saying that, because I went and did a land surveyor outreach recently, and I had this one land surveyor. He's also an attorney, and he owns a firm and a land surveyor. And him and I were just discussing afterwards the complaint process, and again, keep in mind they go through the exact same process you guys go through. They have their own expert reviews as well, licensees that look at it. And he was just, and you got to imagine too, if you're a conscientious person, you already feel like you're on defense, because you have this allegation. The state is sending you a letter, and there's allegations of USPAP violations, and then now you're waiting, And the problem, it's also, it's a good thing, but it's also a problem is due process. It does take time, and it should take time. You have to make sure that everybody is protected. But I think one thing I tried to give him assurance, just talking to him, is that the state isn't acting arbitrarily or capriciously. There is a standard that has to be validated. And then the appraiser themselves, so you're going to have two different appraisers that are going to look at it, the expert reviewer, and you're going to have the board themselves. They can just dismiss it. They're like, yeah, there's nothing there, And so you've got that. But then the appraiser themselves is a check and balances. They don't have to sign it. They can go to a formal hearing. Then there's an appeals process after that. So there's another checks and balances. But it's uncomfortable that you even have to do that in the first place. But the thing is, you also have statutes and rules that require you to log the complaint. So it's not so you can't get around that piece. And so you have to send out the letter for response. You have to investigate it. Now those investigations can be very quick, because you look at it and you're like, absolutely no jurisdiction. There's nothing there. That's a close. That's pretty simple. But you still have to send out the response and that sort of thing, or determine that there's nothing there out the gate. But it's not. I don't know how we get around that piece, But no one's looking. I told him, no one's looking to sort of zing you. They're not trying to. It's got to raise that to that threshold of a violation, and as decided by multiple people, to include the appraiser themselves. Otherwise, don't sign it. I wouldn't agree to something that I didn't do. You wouldn't. I hope you wouldn't just take a plea bargain because and commit. And state that you committed a crime you didn't commit. I'm talking about criminal law. It's a different animal, but trying to make the, something that we all understand. So I do appreciate what you're saying. I'm glad you said that, because I think a lot of folks, I try to put myself in their position. That's how I would feel, how you described, especially, and then typically the more conscientious you are, the more you're going to be sort of in tune with that. And so I appreciate that. but we still have to go the process, and that's now we can move the chairs around, maybe order of the process, but the thing is, you're still hitting those checks as you're going through that process. Where you bring in the expert reviewer, where you don't, but you're still getting the expert review, in our process, or we might move that chair a little bit further up here or a little bit further down there, but they're getting those protections. The appraiser is as well, and it has to be substantiated. And there's times where I've seen prior boards even before, that would question the expert reviewer and say, hey, look, I don't think there's, so we can send it out again, or I don't agree. You don't have to take the expert reviewer's position on it either. You can say, but just based on the stuff I've got here, I don't see it. Can we look at that again, or maybe we just dismiss it? But so yeah, it's uncomfortable for if you're on the end of that, the receiving of that, and I appreciate that. Thankfully, by God's grace, we live in Tennessee, and so there's we follow the law here, and I like that. So. There's not this capricious sort of zinging everybody, and the board isn't just an entity unto themselves. They flow out of the executive branch and appointees that enforce the law. A novel thought, isn't that? As determined by the legislators, and so there is limited discretion. The only discretion that's allowed to us is that expert sort of that when there's not in black and white. And it becomes very clear where that discretion is, where you need the expert. But short of that, it's pretty clear, and there's a lot of guardrails there for the appraiser. So I think that's good news. If I didn't sit on this side of the table, I would probably be a little bit more uneasy, But actually seeing the process, I realize that there are protections there for the appraiser as well, and for the public. So it's hard to strike the balance, but you got to find that balance. Yeah.
Glenn, as a comment, I appreciate the fact of being concerned about the consumer and protecting the consumer, but I'm also concerned about protecting the appraiser.
Sure, they're the public.
And I come to this from a different situation. I'm an academic on this board, and I've honestly been a little surprised with a couple of the reports we've had to review. And even though they've been recommended that we close them, I've been surprised they got to us. And they haven't taken us much time, but I guess I've never considered the fact of how much time, effort, money has been spent, not only by the state, but also by the appraiser themselves, dealing with something that frankly looked frivolous.
Right. Sure.
And as we've been talking about this, I've been thinking about this from an academic standpoint. We deal with students wanting to appeal grades, but we've got it set up very carefully that they can appeal a grade, but there's only certain categories they can appeal it based upon. It has to be based upon something in the course syllabus or this or that. We can't have a student come in and say, well, I think I deserved a B and I got a D. That's just not a basis for an appeal. That will not even be considered. Won't go anywhere at all. And I wonder sometimes whether in our attempt to protect the consumer, we may have gone too far. And then whether we need to be careful, and again, I have absolutely no idea how much is spent, not only by the state, but also by the appraiser, and how much time is spent on cases that are very apparent right off the bat, that are just not something we should be considering. Now, I'll be candid, I want to protect the consumer. If we got a bad apple out there, if we have an appraiser who's not doing their job, is not following policies, then we need to deal with them. I don't want that to be misunderstood, but I think we have some situations where someone is just not happy. They didn't get the loan they wanted because they didn't think the property was appraised properly. They don't understand appraisal, and they're filing a grievance because of that. So
no,
I don't know how we deal with that, but I guess I had not thought about the other standpoint of how much is really invested before we even see it ourselves. So.
Yeah, I'll speak to that as from the appraiser side and some of the concerns that were brought up. So, the process is, as we've discussed, is black and white, and really the document that we're supposed to be enforcing, though, is not black and white. So, the very first USPAP class I sat in, the instructor said, I can find a USPAP violation in every report I look at. And so it is vague, and so it's not black and white. And so if a complaint is filed against an appraiser, for any time you resubmit your E&O, it doesn't say, have you been convicted by the state? It says, has a complaint ever been filed? Same way with applying for an appraisal management company. And so, again, there is a significant financial impact to an appraiser when a complaint is filed. And so I think that's where a lot of the concerns are coming from. I do have one question about he had mentioned the attorneys within the state. Does that fall under the Department of Commerce and Insurance? Attorneys?
You're talking
Their
about our
licensing?
attorneys?
Yes.
Yes.
Yeah. Oh, no,
it doesn't.
no.
Okay.
That's separate. He's
Gotcha.
talking about the.
Because he had
Board of
mentioned a
Professional
slightly
Responsibility.
different setup
Yeah,
that
no,
they have. and I
they're
didn't know if
completely
that was-
separate, yeah.
Okay. Any other comments? Okay. Well, I think we're at a good point where, if the commission will kind of put our heads together and send you something individually, and then this will be up for new business at our next meeting, and we can kind of go from there. Thanks.
Chair, we have the red line rules and legal report next. Do you want to push through, or would you like to pause for maybe a 5-10 minute break? We've been going for about hour 15.
Yeah, I think a 10-minute break would be great.
You want about 10 minutes?
Yeah, I think so.
All right,
So that-
it's 10:16 now. You want to come back about 10:26?
Perfect.
All right,
Thank
thanks,
you.
Chair.
Okay, we ran a little bit over there, but we'll get back on track. I think we are ready for the legal report.
Red line rule, sir.
Good morning. I have another package of rules before you today. The first, just to give you kind of an overview of what these rules are, if you remember, I don't remember when we talked about this exactly, the date, former Assistant Commissioner Alex Martin came before you in the executive session to talk about certain changes to the rules that were going to be made related to the retrospective rule review that was required by the statute passed by the General Assembly, which requires us to review all of our rules and regulations. So those proposed changes are what I have before you today. They're just here in red line form, so I'll go through them. If you have any questions at any point, let me know. So the first one is going to be an amendment to 1255-01-.04. So we'll be removing the fee related to the application upgrade and also related to application for temporary authorization and issuance fees. Those are going to be removed. The next one is going to be to that also same rule, paragraph 7. It's related to the payment of application fees. It's just going to be amended to say that those can also be paid by credit or debit cards because, yes, we want that to be to happen. The next one is going to go for 1255-01-.05. It is for the qualifications for state licensed appraisers. There is a provision related to experience that states, if you look at paragraph 5, number of actual work hours by the trainee applicant on the assignment, and then it states up to the maximum allotted by property. That's going to be removed as that's not a requirement. That's going to be amended also in 1255-01-.08. So they're still required to tell us the number of actual hours by the trainee applicant. It just doesn't have to include up to the maximum allotted by property type. The portion, next one is 1255-01-.08. So this was actually on our previous rulemaking package, but it had to be striked because there was a typographical error, so it is going to be put back on this package for amendment. So this is actually related to the changes that were brought to us by our last ASC edit. We have included that it is specifically for, previously it stated state certified appraiser, and that the word general was missing. I think it would have been okay in the long scheme of things, but just to be very, very, very careful, I'm going to put that back there. The next amendment is going to be to the registered trainee rule, 1255-01-.12, related to experience. And so it's going to state individuals are required, they can conduct property inspections alone after completing 500 hours or until the supervisory appraiser determines that they are competent in accordance with the competency rule of use PAP. That's a change that has been needed for a while. The next one is going to be an amendment to 1255-06-.01. This is related to reciprocal agreements. It is removing the application fee of $125 and reducing the fee from $350 to $325. We all love fee reductions. And then the last amendment or change is going to be related to 1255-06-.03, related to, this is related to expedited registration for military spouses and personnel, and it's going to remove sections 1 and 2 because we removed those fees of the temporary authorization for $31.25, and it's just going to include that information, the text that states to paragraph C, saying a temporary authorization shall only be extended for good cost by 1 6-month increment at a time, which is already in rule, but since we're removing paragraphs 1 and 2 and the fees with that, we're just moving that up to paragraph 6. If there are no questions related to the rules, let me know. If you have questions, let me know. Otherwise, I'll need a motion to approve this so we can proceed with the process and go for a hearing.
We need to take a roll call vote here.
No.
I'll make a motion to approve.
Second.
Second.
Okay, got a motion and a second. All those in favor?
Aye.
Aye.
Any opposed? Okay, motion carries. Okay, now I think we're ready for the legal report.
Yes, it is time for the legal report. Since there's just a few, I'll just briefly go over each one, and then we can vote on them. Number one is 2024-002-001. In this, complainant alleged that respondent improperly used the hypothetical condition.
Aye.
Any opposed? Motion carries.
Just 1 second.
No, you're good.
If you're online, please mute real quick for us. I appreciate that. All right. Go
Okay.
ahead.
In this, the complainant alleged respondent improperly used a hypothetical condition. However, an expert review was conducted, and the expert agreed respondent clearly disclosed the hypothetical condition in the appraisal and how its use could affect the opinion of the final opinion of the value. As such, I was recommending closure. Any questions on that one? Or?
I'd like to just say that I am going to recuse myself from this case.
Okay, thank you.
Any discussion? Well, I'll make a motion to accept council's recommendation.
Second.
Okay, we've got a motion and a second. All those in favor?
Aye.
Any opposed? Motion carries.
Okay, number two is 2024-01-8921. In this, respondent was hired to appraise complainant's property after a city in East Tennessee attempted to obtain complainant's land by eminent domain. Complainant alleged that respondent had a conflict of interest and therefore their appraisal was affected. Respondent denied complainant's allegations. They explained that they have been an elected member of the city council since 2008 and have been an approved appraiser since 1990. They say for the last 15 years they've been doing solely eminent domain work for the local government. In TDOT, there does not appear to be any violations under our jurisdiction pertaining or any evidence of any conflicts of interest on behalf of respondent. As such, I was recommending closure.
I make a motion that we accept legal counsel's recommendation.
Second.
Okay, we've got a motion and a second. All those in favor?
Aye.
Any opposed? Motion carries.
Okay, number three is 2024-002391. In this, complainant is a funding company who is alleging that respondent was falsely representing themselves as an approved appraiser for their company. Respondent advises that they are a licensed appraisal management company who serve as an intermediary for and manages appraisal process for mortgage lenders. They advise that they were surprised by the complaint as they were never made aware by complainant of any issues with any appraisal management services provided by respondent. They explain that they have a complaint and dispute resolution process and would have immediately implemented a solution had they been made aware by complainant. They say that they were never made aware that they were placed on an exclusionary list, and they have since updated their systems to ensure orders for complainant are rejected going forward. This matter appears to be outside of the jurisdiction, as there are no violations under the commission's rules. As such, council recommends closure.
I have a question on this one.
Yes.
So it's an appraisal management company, yet there's an appraiser who works with the appraisal management company?
They were saying the appraisal management company as a whole was placed on an exclusionary. So the complainant is a bank. It's a funding company. And they were saying that complainant was advertising them. I'm sorry, respondent was advertising themselves as an approved AMC by their bank. Falsely. And then respondent explained that they were never put on notice of this. They weren't aware that they were not supposed to be accepting jobs from this bank anymore, and that they have since updated their internal procedures. And so there didn't appear to be anything that fall under our jurisdiction.
So the appraisal management company was saying, hey, we're so-and-so bank's appraisal
Yes.
management. And
That's what the complainant was alleging, yes.
Any discussion?
Sorry.
Make a motion to close.
We have a motion on the floor. Any further discussion? We need a second.
Second.
Okay, we've got a motion and a second. All those in favor?
Aye.
Aye.
Any opposed? Motion carries.
And the final one is number 4, which is 2024-014351. This complaint was open after respondent self-reported their discipline in Illinois. Respondent explains in 2020 they completed several appraisal reports with the assistance of trainee appraisers. Respondent notes the report acknowledged the trainees' contributions, including their names and license numbers, indicating significant assistance was provided. However, they failed to fully detail the nature of the trainees' involvement. As such, they were disciplined by the Illinois Department of Financial and Professional Regulation. They were required to pay a $10,000 civil penalty, complete a 15-hour use PAP course, and were restricted from supervising trainees for 1 year. Under Tennessee Code Annotated Section 56-1-313, the Commission has the authority to discipline a licensee who has been disciplined in another jurisdiction. As such, Council is just recommending closing this complaint with a letter of warning pertaining to the violations found within the Illinois discipline.
Do we know if they fulfilled the discipline?
They did.
Okay.
Motion to accept.
Second.
Okay, we've got a motion and a second. All those in favor?
Aye.
Any opposed? All right, motion carries. And
That
will-
concludes the legal report.
report. Excellent. Okay, we are ready for new business. We can talk about the review process more, or?
Chair, it's your prerogative. If there's no new business, you know,
Okay.
then you can.
No new business, then we don't need a motion or vote, so we're adjourned. Thank you.
Actually, I'm just kidding.
No, Anna.